Yes.
Your Lordship, I beg to mention WPC number 326 AP of 2025 for listing, Your Lordship, tomorrow, 27.
For what purpose? Admission, hearing.
For
Tomorrow.
Madam, may I mention item number 16, 17, and 18 orders method, madam. Madam, we are appearing for the madam, the respondents. We wanted to file madam, the affidavit in detail, madam. And in fact, we have taken the consent of the madam, the counsel for the petitioner also, madam.
16, 17.
18, madam. All are analogous matter, madam. Madam, let me
Oh, you are seeking an adjournment for filing
affidavit, madam.
affidavit.
Yes.
For how long?
Madam, by next week, we'll file, madam.
Mr. Kato, your DSGI.
No, my lord. Here I am appearing on behalf of my lord, the Arunachal Pradesh State Human Rights Commission, madam.
Council appearing for Arunachal Pradesh State Human Rights Commission. Prays for a week's time to file the affidavit. MS D. Ghosh, the council appearing for the petitioner, does not object to the prayer made, but submits that the interim order passed these matters be extended. Accordingly, matter be extended after what you're appearing.
Yes, Your Lordship, for Election Commission of India, but we have not been furnished with a petition copy in all the cases.
And as soon as appears for the
Election Commission.
on prayers made, list after 1 week. Interim order, wherever passed, the extended one.
No objection.
We prayed for 1 week. You're giving more than 1 week.
Yes. Subject to convenience on the part of the my lord, the Guwahati-based lawyer.
List this matter as agreed to list this matter on 15th
Smile.
September.
Development.
Item number 1.
I have realized this matter will be taken up day after tomorrow, sir. I have the instruction is on the way, sir.
I'm sorry.
Instruction is on the way,
Instruction is on the way.
so day after tomorrow.
Day after tomorrow. Yes. Day after tomorrow. On the request made by Mr. S. Tapitwana City Government, that the instructions are is yet to receive the instruction. We submit the matter taken up day after tomorrow. Prayer made is not objected, please accordingly.
Item number 2.
Lordship, same prayer in this item also. Day after tomorrow. This transfer matter.
Transfer.
It states order is there.
Lordship, I haven't transferred without assigning any reason. So, on last hearing, status was fast against the transfer order made by the respondent authority. So, this case is fit to be set aside since they are
They're waiting for his instructions. You have to
instruction.
take it up.
Lordship, is not necessary at all because there are no any ground to transfer me. Since there is political interference, not it is there, political interference is there.
But we'll take
Total
it,
violation of the established law established by
we'll
the
take it up next.
Day
I'm sorry, day after tomorrow. Day after.
courts. Then status quo to continue.
Yes, day after tomorrow. Interim orders where passed will continue.
Public.
Item number 7. Item number 6. Item number 6.
Whatever.
Not adjourned, lordship, sorry. Item number 3.
6 or 5?
3.
Item 3, na?
Yes, item number 3.
Like your new port, we have a new port master. Give us some time to get used to it. Yes, who's appearing? None appears for the petitioner on board. None had appeared for the petitioner, but the matter was called on 22/8/25. Purely for the ends of justice passed over for the day.
Item number 4.
My pleasure. Lordship, this petition is for non-payment of entitlements, any entitlements, Lordship, to one disabled person who has been suffering from schizophrenia, Lordship. Lordship, before going to the facts, Lordship, I'd like to put your
What are you claiming?
Lordship, so far, Lordship, law is concerned, he is entitled all benefits, Lordship, including the salaries, Lordship. And when the disability benefits also, Lordship. I deal one similar case in the municipal court, Lordship.
No. Who are you?
Lordship,
Who's
I am the
petitioner?
brother, Lordship. I am the brother, Lordship.
Ah.
I am the ladder, being a brother, I am his legal guardian.
On what basis are you making this statement?
Lordship,
On what basis are you making the statement that you are the legal guardian?
Lordship, I am going to that, Lordship. The fact is that prior to that, my mother represented, Lordship. Before the authority, Lordship, submitted representations, her application was rejected. Thereafter, she,
Your deceased brother was not married.
Lordship, he is not married, Lordship. Lordship, he married, Lordship. He also lost his wife, Lordship. He lost his parents, Lordship, father, Lordship, and mother, Lordship. Thereafter, Lordship, and Lordship, so far present Act is considered the Rights of Persons with Disability Act 2016, Lordship, permits one, so Lordship, limited guardian, Lordship.
But he's not there.
Who is that?
The limited guardianship is during his lifetime. He is expired already.
No. He is not expired, Lordship.
Your brother
Lordship, the employees, Lordship, say, still there, Lordship.
is there.
Yeah, Lordship. Lordship, first of all, your Lordship, may kindly come to page number 15, Lordship, disability certificate, Lordship, issued by the Government of India, Lordship, on 27/5/2022, Lordship. Followed by that, Lordship, one unique disability ID was also issued to my brother, Lordship. To my brother. He has been suffering mental illness, Lordship, since the year 1992, Lordship, while he was in service, Lordship. Lordship, the fact is that my brother was appointed as Assistant Conservator of Forest, Lordship, on 4th July 1989, Lordship, which is at page 22. Page 22, Lordship.
You should notice here, Mr. Tap. But council parties. You should notice return of 4 weeks. Mr. S. Stopping. Leonard Singh, Governor Advocate. Appears on behalf of
All the rest.
all the disciples. Therefore, notices of waived, extra copies be furnished. Instead after the return of the
So, Lordship, take the date, Lordship, on 25th October, Lordship, if possible, Lordship.
25th October,
21st October, Lordship.
21st October.
Lordship.
Right? Is it all right? 21st October? 21st.
It's open, Lordship.
First week of November. Motion.
All right. 3rd of November? Or you have it in the last week of October, 27th October. 27th. It's not 27th.
Item number 5.
Lordship, matter pertains to non-payment of contractual bill, Lordship. And the petitioner is a proprietor of Taylor Engineering, Lordship.
Yes, Mr. Kato.
Madam, the respondent number 20.
It's appearing for responding to
Respondent number 2 is
Power case, madam.
Power Grid, Lord.
any council.
Okay. No point.
Yes. We are giving a short date. But council for parties should notice later on 3rd of September. It's the cut. Yes, yeah, yeah. What? Steps of this. By registered posting. There is study council also? Margaret?
Correct.
But then I don't know whether on 3rd it is possible.
Should can it be on 8th Lordship? 8th.
On 8th. It's not 8th of September.
6th.
6th of
6th is also
5 and 6.
Five.
5 and 6. Same order.
Item number 7.
Notice.
Yeah. Which part
Are the
of this? Execute. And respondent 4, we are agreed by a regularization.
Not exactly retrieving, but seems much new. Even the
You're not challenging a regularization.
say that thing in the party as a performer. I wanted to maybe accepted that.
Spite of. By respondent. Stop. On the other hand, persons junior to the petitioner, like respondent 4, they considered for regularization. Stop. In spite of representations 5, the case of the petitioner was not considered by the respondent parties. They agreed to present the petitions 5. Better. Upon consideration of the submissions made, this court is of the view at this stage notice be issued. That notice issue returnable 4 weeks. Now, Mr. So-and-so. You're Mr.
G Tarak,
Jitara,
standing counsel of the,
Standing Counsel RWD,
yes,
accepts notice on behalf of
one,
respondent 1, 2, and 3. Steps on respondent number 4 by registered post AD as well as EQ posts. Might be listed after return of date.
so,
Item number 8.
Yes.
Lordship, this matter is in fact connected to WPC number 329 of 2025, Lordship. A basic challenge in this writ petition is, Lordship, the petitioner is being aggrieved by the selection process conducted by APSSB, Lordship. Now there, in spite, I was the highest scorer in the whole exam that was conducted, Lordship. In spite of that, I was not selected, Lordship. Later, I came to know, Lordship, through their communications, Lordship. The name of the degree, due to the name of the degree, I was not selected. Now, my degree in the certificate is Lordship, Bachelor of Pharmaceutical Technology, Lordship. Now they want that it has to be Bachelor of Pharmacy, Lordship. Now we have taken the clarification from in fact, the authority, they have taken the clarification from the institute, wherein the institute has clearly clarified that these two degrees, they are identical, Lordship. They are synonymous. In spite of that, Lordship, I was not selected, Lordship. In that previous writ petition, Lordship, we had an interim prayer, Lordship, not to fill one vacant post. It was not filled during that selection process, Lordship. Now, subsequently, they have come up with another advertisement. Now, that is put to challenge in this present writ petition.
Advertisement for filling up that post. Advertisement for what?
Lordship, in that advertisement, in that selection process, 28 posts was advertised, but 27 was selected. One was kept vacant, Lordship.
Now, subsequent advertisement is what?
Subsequent for pharmacy allopathy on.
How many posts? Different posts.
In this, Lordship, total, it is 6 posts, Lordship. One is kept for unreserved category. Now I belong to unreserved category. I'll be competing in unreserved category.
When is the other matter fixed? 329.
Lordship, notice was issued in the last occasion.
But you said
No,
some
no.
interim order.
Lordship.
Said there
No,
was-
no, there is no interim order. In that interim order, interim was there but not considered.
Yes, Mr. Tommy.
Otherwise, whether this particular. It means that goes out.
Wednesday. Monday is the holiday.
Tuesday.
Tuesday.
Static out. Submits that like. They're advertised by the advertisement which is under challenge. Also includes the post in which the petitioner had earlier applied for and was on his rejection, the same is under challenge for the PC number 329 of 2023. With this matter along with the second repairing for but council appears for response. Yes.
Item number 9.
Yes, Mr. Dar.
Malad, the basic challenge in this writ petition is that 19/8/2019, the principal Sainik School, Pasigat, issued advertisement for the accountant and some other posts. The written test was done, Viva Boys was done, computer examination was done. And then, Milord, since then, and on Milord, 18/10/2019, no, 28/10/2020, he congratulated me by our email saying that you have been selected, congratulations. But thereafter, there is no communication from their end. But pertinently on 27/7/2025, without giving me the appointment, they have issued a fresh advertisement. Now, my lord is aware that Aravinda Rava case, which was authored by my lord, and relating to the appointment of 104 forest guards. And finally, the apex court very recently has held that although state government do have the discretionary power, whether to appoint or not, subject to a decision taken with a rational nexus by giving appropriate reasons. But in this case, my lord, there is no such communication to me. Now, my lord will see at page 23, my lord.
When was the selection?
Well, I'm coming to the fact that was the brief outline of the matter. My lord will see at page 22 is the advertisement. And then, my lord, I am concerned with page number 23, accountant. Advertisement dated 19/8/2019. Yeah. So I'm concerned with page 23, accountant SSL qualification. That I have done.
Yes.
Now, my lord, will kindly come to page 27. Page 27 is the call letter issued to me. And then, my lord, will kindly come to page 30. Annexure 3, my lord. This is the email communication dated 28 October 2020. My lord will come out, Raj Kamal Gupta after that. Kindly see Principal Sainik School East Siang. Hello, Mr. Kamal. Heartiest congratulations. You have been selected.
Page number.
Page number, my lord, 30. They said, hello, Mr. Kamal, heartiest congratulations. You have been selected. Then he said, the reason he has given is, thereafter he writes, the coronavirus pandemic situation has led to a lot of difficulties, which has resulted in delay of some documentations. You will be informed and further updated very shortly, probably within a few days' time. Now, my lord has seen this is 2020 communications, and thereafter, my lord, there is nothing. Now, my lord, kindly come to Annexure 4 series, the communications. I have done my beat, my lord. Thereafter, kindly come to page 35. Page 35 is 35, then thereafter 30, 36, 37. These were the communications that I have made.
Yes. Then
So-
what was the information?
Nothing.
Nothing.
Nothing, no communication. Even, my lord, the result was not declared, my lord. But the communication, my lord, has seen at page 30, where he has congratulated me that you have been selected. And thereafter, nothing has happened. But pertinently, my lord, kindly see, then we have gone to the Central Information Commission. My lord will find at page 38. The order was given directing the PIO of the Sainik School Pasigat to furnish the informations, but no information was furnished. Then I have made a categorical statement in my amendment. Now, my lord will see page 38 is the order dated 21/8/2024 passed by the CIC.
What is the status today?
Now, my lord, the status is kindly come to page 46.
Another advertisement.
No, my lord, not application. This is the impugned advertisement which I have put into challenge. My lord.
Second advertisement.
Yes, second advertisement. And then, see, my lord, the law is well settled. Once you have completed the recruitment process, and then you have to declare the result, also intimating that you have been selected. Then the next course is, my lord, to issue the appointment letter. But this has not done, and there has been no communication. No, any reasons has been assigned, impregnated with reasons, my lord. My lord is aware, any administrative decision must be based with rational nexus. So this particular object is completely missing in it. Now, my lord, I have this judgment, my lord, apex court. And my lord ordered this judgment in the division bench with Justice Dulia. Because, my lord, I'm relying it because I'm praying for an interim order of the stay, interim order for staying this advertisement. my lord, fact is from paragraph 1 to 17, my lord, those grounds. Now, my lord, I'll request my lord kindly come to paragraph 48 onwards, my lord. Paragraph 48 onwards.
Right.
If my lord,
Let us hear what the
law is clear, without,
My lord,
what do you have to say?
my lord, my submission is, my lord, other way, my lord, law is very clear. This is mere, my lord, the communications made to the, my lord, the petitioner. My lord.
That's right, but why have you not informed him? He is not selected. Tell him he's not selected.
My lord, after this, my lord, the press, advertisement has been issued.
Uh,
Maybe, my lord, this have certain reasons.
no, not come to pay the page number 23.
23 months. Yes, ma'am.
This is one post.
Yes, ma'am.
Right?
Yes, ma'am. Since accountant
Now,
and one post and number of posts, one
and,
madam.
the recent advertisement is also one post.
My lord.
So it appears that perhaps no one is selected.
Yes, ma'am.
Now he appeared, you are supposed to at least
My lord, altogether,
intimate him.
my lord, altogether, my lord, the advertisement post for filling up is, my lord, altogether, my lord,
No, we are concerned with only accountant.
my lord, accountant along with others also, my lord, they have, my lord, cancelled, maybe, my lord.
Maybe.
Thereafter, my lord, the fresh advertisement has been issued, my lord.
So you get your instruction here.
Yes, ma'am. I'll take instruction.
my lord, kindly stay this.
So stay, you want a job or you don't want a job?
My lord, there is one.
Now, say in a subject to what instructions come. Supposing the advertisement was cancelled earlier,
Correct.
process was
Correct,
cancelled,
correct, correct.
they have proceeded to hold afresh. Would you not like to apply?
No, my lord, here,
Huh?
in this Aravinda Ram,
If the earlier process is cancelled,
So therefore, my lord, at this stage, no, my lord, we'll take
no,
instruction.
my lord,
Come with the clear instruction.
why I am trying to convince my lord, I have to do my persuasions on it. my lord. Ultimately, it is my lord who is going
we
to
will
decide.
accept your persuasion. But first, let us understand what has happened
Yes,
to the earlier procedures, earlier selection. If the selections are cancelled, abandoned, can a court direct them to proceed with that? If the reasons are found to be justiciable for cancellation, it's possible because of corona or whatever reason, they may have decided that we want to cancel.
My lord, this paragraph 53
Uh.
is very loud and clear.
Let us read.
Without cancelling the earlier thing and being communicated to me, you cannot
Right.
proceed with.
That's right. So therefore, we want him to get the instruction.
Fine, brother.
Right. So let him get the instruction.
Yes.
Short date, brother.
Short. You tell me.
From Pasighar. Because his officer, my lord, his officer is a commander of Indian Navy. And that army, Fauji men typically have certain egos. And that even the directions of the CIC, Central Information Commission, has not been complied with. So I don't know when he can convince him to furnish the documents.
On fourth.
Huh?
Fourth. Heard Mr. P. Tavaran from page 73 and Mr. Apu. Then at the hearing for me. All the respond?
yes.
The petitioner is aggrieved by the advertisement dated. What is the date of this?
27/7/2020.
Where does one find the date?
Annexure 1.
No, your
Impugned
advertisement is
page 46.
27/7.
Yeah, page 46.
Yes.
Annexure I.
Where is the date of the advertisement?
The date
27.
So where do you find the date?
Page 46, my lord, that 54, my lord will find it.
Last page,
54.
54. That's right. 27/7/2025. Whereby the Sainik School, East Siang, Niklok Village, Arunachal Pradesh, has issued an advertisement for regular and contractual posts to direct recruitment for several vacancies arising in different posts slash cadres under the school. One of the posts advertised is that of accountant within bracket regular. Stop. It is the claim of the writ petitioner that earlier, by an advertisement dated
19/8/2019.
19/8/2019, the Sainik School had issued an advertisement for several posts, including the one post of accountant. Stop. Petitioner applied for selection to the same post of accountant in terms of the earlier advertisement. However, no information was forthcoming as to the status of the selection process. Stop. Counsel for the petitioner refers to the communications exchange between the petitioner and the school, and by an email dated 28th of October 2020, petitioner was informed that he was selected. However, no orders for appointment were issued thereafter. As the petitioner pursued the matter by filing several applications, but no information was forthcoming from the respondents. Ultimately, the petitioner approached the filed an application under RTI, and the direction was issued to the respondent to furnish the information sought for by the petitioner, which, however, has not yet been furnished. Stop. There. Being thus situated, he was surprised to notice the advertisement dated so and so, where in one post of accountant regular is advertised. Stop. It is the apprehension of the petitioner that, in spite of the petitioner having been selected, as have been communicated by the email dated so and so, and without issuing him the appointment order, the authorities have issued the impugned order proceeding to fill up the post of accountant regular, and which according to the petitioner is contrary. Counsel for the petitioner has referred to judgment of the apex court rendered in state of Assam versus Aurobindo Rava, reported in 2025 SCC Online SC 523. To submit that unless the authorities cancel the earlier advertisement and communication thereof are issued to the petitioner, subsequent selections cannot be proceeded. As a let the matter be listed on September. After the first line, after the partner might not be reported, the person that advancement, the petitioner has cleared the written test, computer proficiency test, and the Viva was.
Whether is that.
Then next submission would be you tell us how much marks you have got into.
May I just make a opposite submission? Indulges. May I request to aid one particular without the leave of this court?
So, but if you want to participate, then the entire advertisement is installed.
Only with that, only in respect of accountant post, that much.
We consider it on the next day, depending on what information comes.
I am grateful.
Prayer for interim, council is permitted to review his prayer for interim on the next day fixed. And great, in order to enable Mr. Kato to obtain the instructions, sufficient copies of the writ petition be furnished.
That is,
By today or tomorrow.
I can furnish, give it,
You can give him soft copies if you want.
yes, I'll furnish everything
Today, man.
during course of the day.
During course of the day.
Get to that.
Item number 10.
My lord, this writ petition is arising out of the illegal enrollment of 14% from other gram segment to other gram segment, of other panchayat to another panchayat. So you kindly come to page number 32, my lord. 32. My lord, this is circular 32, my lord. This is the circular issued by the electoral registration officer, K. Pioneer District, yesterday. My lord, here, after the summary revision of this electoral roll of 2025, this circular was issued for claimant objection, for filing claimant objection. Here, fixing a different date for different Jilla segment, my lord. There are two rounds on. There are two rounds, my lord, on different dates. Kindly come to page number 33, the type copy, my lord. It is very visible, my lord. 33 onwards, visible. So again, kindly come to page number 34, my lord. Here I am at serial number 6, my lord.
Yes.
Yeah. So, my lord, here, this deed is name of the village and is one of the Jilla segment, my lord. So, claimant objection is fixed on 27/5/2025 at CO office date for filing of any claimant objection. So, my lord, accordingly, the petitioner were appeared there, we attended to the petition on hearing day. And on that very hearing day, my lord, on 27/5/2025, the assistant electoral registration officer White here, who is the CO circle officer of the D circle, my lord. The electoral registration officer White not there, but instead of him, the circle officer, the concerned circle officer White discharging the duty as a assistant electoral registration officer. And then when this particular neighbor village is there, them is one of the them is the name of the village is also having a 2 panchayat, my lord. Them and the rich. The two village, one village is divided into 2 panchayat, my lord. Now on this day, 27/5/2025, this assistant electoral officer was not allowed to participate in that claimant objection, my lord. Whereas some persons were enrolled in the Namko Tago Gram segment from other panchayat as well as the other segments. So we have dared to lodge a complaint, participate, raise the issue before the assistant electoral officer. But we have not been allowed to participate. We have not been allowed to enter in the room to raise the objection. So my lord,
What has happened to that hearing?
we have not been allowed to enter into the room, my lord. After 4:30 p.m., we were there, but we have not been allowed. Then the proceeding of the claimant objection was closed at 4:30 p.m. So we have not been allowed. Our turn had been come, but we have not been allowed, and the proceeding was already closed.
Who prevented you?
My lord,
Who prevented you?
the assistant electoral officer, do it the concerned circle officer. The concerned circle officer is automatically,
Did you raise objections in writing?
my lord. And after pausing of the proceedings, then again I have lodged a complaint before the assistant electoral officer on 28th, the very next day. The petition number 1. We have lodged a complaint, my lord.
Page number.
Page number. Kindly come to page number 30. 59, my lord.
5/9.
59, my lord. This is the first complaint on the very next day. That is 28th May 2025. The petition number 1 has lodged this complaint before the electoral registration officer, my lord. But it has not been considered. Again, my lord, May I kindly come to page number 65, my lord. 65, 66 is, my lord, type of it is visible. My lord. Again, lodge a complaint before the assistant electoral registration officer. But this complaint has not been again considered, my lord. And thereafter, my lord, kindly come to page number 68, my lord. The petitioners, they have lodged a complaint before the State Election Commissioner, my lord. It is 69 is visual, my lord. It is a type copy, my lord. The petitioner, they jointly submitted a complaint before the State Election Commissioner, Itanagar, my lord. Where our two complaints had not been considered, not been entertained by the assistant electoral officer, as well the electoral officer, my lord. So again,
This was forwarded.
this was forwarded to the district election officer yesterday on the same complaint, my lord. And 71 is a forwarding letter, my lord. So this is also pending before this district election officer, my lord, agent today. And again, my lord, kindly come to page number 73, my lord. NHR 7. Despite of the forwarding issued by the Secretary, State Election Commission, my lord. Again, this petitioner has submitted a complaint, filed a complaint before the district election officer, my lord. For same cause of action, my lord. But this is also still pending. Now, my submission before this honorable court, my lord, the district election officer, who is the respondent number 2, direction may be issued to the respondent number 2 to dispose of my this complaint, my lord, whatsoever it may be, wrongly or rightly, my lord. Now, this is the only authorized person to dispose of my complaint, my lord. This is my submission or prayer before this honorable court, my lord. And the two-writ petition was filed again the same cause of action, but that was withdrawn. Earlier petition withdrawn on technical ground, and subsequent petition was also withdrawn on non-infringement of this the person who have been illegally imprinted, my lord, in my this ground segment. So my humble submission before the honorable court, whatsoever order may be. So direction may be issued to the respondent number 2, the district election commissioner. No, sorry, my lord, the district election officer, final district yesterday, to dispose of my complaint. Whatsoever order may pass by the district election officer. This is my submission for this court, my lord. Yes.
My lord, it's a electoral registration process, my lord. There are certain process, my lord, and certain deadlines also. My lord will kindly see page 33 itself. The page 33, whereby circular was issued. My lord will kindly see circular. The hearing for claims and objections of Jila Parishad. It says that hearing for claims and objection of Jila Parishad constituency of so and so in connection with special summary revision of electoral roll of Panchayat Raj with reference to 1st January 2025 as qualifying that is fixed on as below during so and so. This particular petition is connected to serial number 6 with in connection of deed 5 deed. That serial in the page 34, serial number 7, first date was 17/5, then second date was 27/5. 900 hours, 5 did so and so, CO office did. Therefore, all the POs, PLS of Jila Parishad's constituency of Kipanjor district are directed to be present during the hearing of claims and objection. Now, this is important. The applicant listed in Form 7, 8, and 9 shall attend the, in person with documents in original. What is 7, 8, and 9, my lord? For that, my lord, because my lord,
This is the Arunachal Pradesh preparation of electoral rules, my lord. It starts from page 54.
Yes.
At page 54, I'll take your lordship to directly to page 59. Rule 17.
Yes.
Every claims for the inclusion of name in the roll and every objection to an entry therein shall be lodged within a period of 7 days from the date of publication of the roll in draft. Then provided so and so, so and so. Then what are the forms, my lord? In Rule 18, it says every claim for the inclusion of a name in the electoral roll shall be in Form 4. For inclusion in Form 4.
Yes.
For every objection to the inclusion in Form 5. Then every objection to a particular or particulars in an entry, it will be in Form 6. Thereafter, my lord, I'll directly take your lordship to Rule 20. Every officer designated under Rule 20 shall they maintain in duplicate a list of claims in Form 7, a list of objection to the inclusion of names in Form 8, and a list of objection to the particulars in the entry in Form 9. Here, those who have already objected, their list has been prepared. Therefore, this circular, it clearly mentions that those who have been mentioned in the list Form 7, 8, and 9, they have to appear in person, madam. I will kindly come back to page 34. Applicant listed in Form 7, 8, and 9 shall attend in person with documents. Meaning thereby, madam, the hearing will be conducted on this. Those who have already filed the objection for inclusion for the entry. Now he files, when he files his objection,
What is their objection?
that
What is
is
their objection? Inclusion in the roll.
inclusion in the roll.
Form 4.
Form 4, they should have filed in form objection.
Sorry,
Form 5. Objection to the inclusion, Form 5. My lord will come back to Rule 18.2.
yes.
Every objection to the inclusion of a name.
So you want to say that they have never filed any objection?
They have never filed any objection. In
Oh.
fact,
Form 5.
yes. In fact, if my lord comes to page 59, and then this is annexure 6, that is the very next day after the last date, my lord, of hearing, my lord, 28 May 2025. Their annexure also is in Form 7, my lord. Page 6. They should have filed in Form 5. Then the entry would have come in Form 8. So, my lord, that's simple.
Where is their objection?
Ob-
The writ petition.
Objection. Their statement, my lord.
Not enclosed.
No, my lord. Their objection is that at page 59 only, that do not belong to Tage segment. This is the only page 59. This is the as subject mentioned above. I am to state that given below marked following persons are not belong from Tage segment. In this connection, I strongly object to the inclusion of these persons in Tage segment. So you are requested to take necessary action from your good end. And this is in Form 7 they have.
This is after the hearing.
After their hearing, 27 was the last date of hearing. This should have immediately after the draft.
Bring it on record.
Yes,
It appears that you did not file it in the form required.
My lord, I want to justify my learned president that I have not filed forms 5, form 7 and form 8. My lord, I have already filed, that is already in the record of district election officer. It is already in the record.
You get your instructions.
yes, ma'am.
You
Notice
need to
my
notice
issue,
them here.
because this is a time-bound exercise and election, this process.
Since the records will be necessary,
Yes, ma'am.
Yes.
better to issue a notice.
Yes, madam. And then I have one more objection, my lord. Here, electoral registration officer and district election officer are made party, but here the state election commission has to be made a party.
Now in the
Necessary.
Panchayat, my lord.
Because
Panchayat-
although the officers are from the district administration, but this process is under the state election commission, my lord. This is a necessary party, my lord. Without,
Where is the election?
Yes,
commission
madam.
report? State election. Sir,
And Tajik.
and that. No. Your additional AG
yes, madam.
of states. You're representing
1, 2, and 3.
one. Are agreed by their not consideration, by the inclusion of the respondents for. You are agreed by their inclusion,
Yes, my lord.
the private respondents inclusion,
Yes.
4 to 18. Names of the respondents 4 to 18 in the electoral roll of which constituency?
From my lord. 5-1 read Panchayat,
Where have you made this statement?
my lord. Kindly come to page number 13, my lord. 14 persons in 515 Namco Tago gram segment of 515 Dam Panchayat from other 581 Pila Lipi gram segment of 58 Read Panchayat, my lord. Page number 13.
Agreed by the inclusion of the enrollment of the names of these private respondents in 5/1/1 hyphen Nemco Tago gram segment from other 5/8 hyphen Read Aldam PTH3 Panchayat and gram segment who are
And
neither
also my lord 5/1 for Forum Gecko gram segment.
no, they belong to which segment?
They are from 1 5/8 Read Panchayat. That is another Panchayat, my lord. And some are from the Forum Gecko gram segment.
And also residents of 5/1/4 hyphen Foram Gecko Gram Panchayat. So these, according to the petitioner, they are neither residents of these areas. And their names were wrongly entered into the enrollment. So accordingly, they raised objections to the electoral officer by filing necessary applications as required under the Arunachal Pradesh Panchayat Raj, Arunachal Pradesh
Arunachal Pradesh Panchayat.
rights in bracket preparation of electoral rules, bracket rules, 2002. These are the rules.
Yes, my lord.
So the learned counsel for the petitioner submits that although they have raised the objections, their objections were not considered and the petitioner were not heard. And consequently, they approached various authorities, including the State Election Commission also,
Yes, my lord.
by filing necessary applications that their objections were not heard by the electoral registration officer. So these applications were also forwarded by the State Election Commission, electoral registration officer, Bangalore district, HP. So, however, in spite of the representations filed and the same being forwarded to the electoral registration officer, their objections were not heard by the concerned officer. They may be presented by the state submits that by submits by referring it is issued by the state electoral officer. So and so district that issued on 28th of April 2025. That it's only the applicants whose names are listed in forms 7, 8, and 9 shall be allowed to attend the hearing in person. The learned additionally submits that there are specific provisions prescribed under the rules and what's the page number? Which prescribes the manner and procedure for lodging of claims and objections. So it is submitted that every objection for inclusion of a name below must be submitted in Form 5 as prescribed under Rule 18. So these forms, these objections submitted in Form 5 will thereafter be included by the designated officer in Form 8. So therefore, it's only those persons whose names are included in Form 8 maintained by the designated officers, office of the designated officer, will be entitled for hearing in person. Stop. Then additionally, it submits that the petitioners did not file the objection in the necessary form. Therefore, their names were not included in Form 8, and as a consequence thereof, they were not given, they were not heard. There is no infirmity. It's per contra, Mr. Dade probably objects to the submissions made by the edition of agreements stating that these objections have been correctly submitted in the forms prescribed and are maintained in the office of electoral officer.
Yes, district election officer.
District election officer with the court record for then their objection better considering submissions made by the council for the parties in the state. Yes, ma'am.
It's too long. Otherwise, final publication will take place, my lord.
2 weeks.
2 weeks, my lord.
That the additionally appears for respondent 1 to 3. Paper notices are waived extra hope, but within a period of 2 working days.
3 days, my lord.
3 days, 3 working days. Steps of the other respondent by registered post ID within 3 working days.
3.
As well as registered post. So, Mr. The learned additionally submits that the state, the state election commission needs to be added as a party respondent, which has not been done. The council petitioner submits the necessary steps, wherein state election commission. Accordingly, this matter again after Anything, you want a fixed date?
Yes, ma'am.
Be after 16. 17th or 18th? 18th in September.
All right.
Okay. We'll have to retain a copy for corrections into the order.
But that is his copy.
But additional AG should be more generous and hand us more copies. Should be required in proceeding.
What's there?
It was there. Okay. For the time being, we'll retain your copy.
Item number 11.
What would the matters to be listed together? Wait. Yeah.
Copies required for
Yes, yes, you have to furnish. You submitted that corrected petition being WPC 380 say, of 25. But it's listed day after tomorrow, so it's a date. Council for the petitioner submits that the petition ought to be listed and heard along. Numbers. So it's agreed to by parties, let's let these petitions be listed again on the day after. Mr. Rapan appears for APSC. First. Anyone else? Mr. Gitaran appears for response. Extra copies be furnished.
Yes, sir. I already furnished.
Item number 12.
Yes.
May I please, Lordship? Lordship, the petitioner before your Lordship is challenging the competency of the Financial Bid Evaluation Board, who has rejected the technical bid of the petitioners in violation of the terms and conditions provided in the NIT, Lordship. Lordship, the NIT was floated on 8/5/2025 for supply of materials under Manrega 2025-26 CD block Lirmova. Accordingly, Lordship, in total, 6 bidders were participated and their technical bids were opened on 23/5/2025, wherein all 6 bidders were qualified. Accordingly, it was fixed for opening of financial bid. Financial bid was opened on 6/6/2025, Lordship, and the board members has rejected the financial bid of all other bidders, but they recommended the single bid of the private respondent number 5. Lordship, the clause 41, clause 14(1) of NIT provides that the technical evaluation bid board has to recommend, after evaluation of technical bid, they have to recommend L1, L2, L3 before the competent authority for acceptance and for finalization of it. But here in present case, Lordship, the board has rejected the rest of the bidders, but they have recommended only one bidder, single bidder. May I take you to the clause, Lordship, 14(1) at page number 41, Lordship. Page 41, Lordship.
Yes.
Clause 14, awarding of work orders. Clause 1, the tender will be evaluated by the boards constituted by DC-CAM, DFC at district level and recommended at least 3 forms, L1, L2, L3, to competent authority for acceptance along with all relevant documents. Now, these provisions are very clear, Lordship. the board member has to recommend L1, L2, L3 along with bid documents for acceptance before the authority. Then Lordship may take it to the Infion recommendation, financial bill at phase 308, last page of my revision. 308, last. Minutes of the financial bid evaluation. The financial bid evaluator for the below mentioned supply and procurement of materials under Mandrega 2526 of City Block Lirmoba, package 5, was often in the office chamber of the project director RD Arlo Western District on 6th June 2025. After completion of technical bid, one by one in presence of bidders, authorized representatives by the board members, so constituted by number so and so dated so and so. Then findings, Lordship. After thorough examination and evaluation of financial bid, along with reference to the norms, rules laid down in CPWD Manual 2014, it is stated that, quote, a proposed provision under FARA 20.4.3, variation up to 5% over the justified rate may be ignored. Variation up to 10 may be allowed for peculiar and in special circumstances. Reasons for doing so shall be placed on record. Tenders above this limit should not be accepted. Unquote. And the same has been reflected in SPD 2526 in additional conditions, serial number so and so. The board recommend the following bidders for approval. Now, comparative statement. Number 1, MSDK Enterprises is the respondent number 5 here, Lordship. And the board recommended his financial bid was found to be L1, lowest, and only this single bidder was recommended for approval. Lordship. Now, the Lordship, the rest 2, 3, 4, 5, and 6, petitioner is at 6, not qualified. NV. Reasons for disqualification of the above bidders from serial number 2 to 6 is that quoted rate is below -10, which is being summarily rejected as per the clause 20.4.2. Now, Lordship, clause 20.4.3 of the CPWD manual, the variations, how the amount quoted, variation up to 5 and within 10, how it has to be accepted, that has been provided under CPWD manual. But my contention is, Lordship, it has to be considered by the competent authority, not by the board members. The duty cast upon the board members is to evaluate the financial bid of all bidders. Thereafter, his duty is to recommend L1, L2, L3 before the competent authority. But by this impugn order, Lordship, they have rejected the rest of the bidders and recommend the single bid of the private respondent number 5. And that too, without assigning any reasons, the CPWD manual 20.4.3 has provided that if the variation is above 5, it has to be accepted by reasons in Britain. In present case, Lordship, the respondent number 5 has also quoted -9.64%. In case, if his financial bid has been accepted, that has to be with reasons in writing. But no reasons has been given, provided. Why? And it has to be in special circumstances, Lordship. While accepting this bid, this financial bid, it has to be with the reason in special circumstances. But that too, it is the power is with the competent authority, not with the board members. This is my case.
Who is the competent authority?
Competent authority is the Lordship. Tender accepting authority is page 35. That is Joint Director, Lordship. Page 35. Schedule F, clause 2.8, Lordship, accepting authority, Joint Director RE, Rural Development Department, Tanah. This is my case, Lordship, since ever that the government instrumentalities cannot deviate from the NIT, terms and conditions of the NIT.
What is page 35?
Lordship,
What is page 35?
for 35 is Lordship, I am showing them accepting authority. Clause 2, Lordship,
Joint Director.
Joint Director. Now, in terms of clause 14.1, Lordship, the board members, after evaluation of technical bid, they have to recommend L1, L2, L3 before this competent authority. Now, it is the competent authority who can reject or accept, and that has to be with reasons that why my technical bid was rejected, on what ground, and why the technical bid of private respondent number 5 was accepted, in what circumstances, that has to be reasons to be given in written. But in present case, Lordship, the board member, after evaluating the technical bid, they instantly rejected all the financial bids of others, including the petitioners, and thereafter they recommend the single bid of private respondent number 5.
Now, what are the conditions in the contract regarding eligibility, the variation clause?
Variation, if they are following the Lordship, CPWD manual.
No, is it a part of the NIT?
Yes, yes.
That is 5% acceptable,
Unacceptable,
below 10%,
10%,
up to 10%.
up to 10
with
that-
reasons.
with regions in written, in special circumstances. And that has to be written.
Page 43, this is the additional conditions, my lord, part of the addition. Page 43. It starts from page 42. Clause 20. It says the tender shall be governed by clause 20.4.3 under section 20 of the CPW Works Manual for reasonability and competitiveness of the rates.
Now, is there any challenge made to these particular calculations? I mean, are you challenging that your rate is not below 10%?
No, Lordship. I'm accepting, Lordship, my rate was also above the 10,
Below 10.
but below 10, Lordship. Lordship, minus, yes, below 10.
So then, how does it give you the, I mean, what basis are you challenging it? Since
Lordship,
technically by the same conditions, you also do not qualify.
yes, Lordship. This is Lordship, this is a bid case for fresh tender because Lordship, the board members, they are not competent authority to accepting the financial bid of the private respondent 5 also. And no reasons was recorded in terms of the CPW demand.
That you can urge only when you challenge that your the conclusion of the board that your rate was below 10% is wrong as per your calculation. That is not your submission.
That is not my case, not my submission.
Therefore, if your bid is below 10%, which is the bar, it is more than 10%.
Yes.
So therefore, by the bid conditions, you are not eligible.
Yes, yes.
Now, whether they should have restricted it to L1 and L2, L3, whether it has to be done, how does it matter?
Lordship, the clause 14.1, it's empowered the board members only to Lordship.
Quite right. But it is only a mere formality, technically, unless you say that or the conclusion of the board that you are below 10% is incorrect. This wrong calculation may have been corrected by the authority who is required to issue the tender. But this is not your case.
Not my case. But Lordship, they are duty bound to recommend Lordship. And moreover, in technical bid also Lordship, I raised the objection, but it was not considered. The one additional ground, Lordship, that is in their technical fault, clause 36, clause 1, which provides for the technical personnel of two from civil engineer and one from diploma in mechanical. But that was also not furnished, not submitted by the private respondent number 5. At that point of time, I have submitted representation objecting the acceptance of technical bid also. It was not considered also. So Lordship, my ground is though I have qualified below the 10%, quoted below 10% also. Even in that case, Lordship, the recommendation of single bid of private respondent 5 is by the not competent authority, that is the board members, Lordship. In that case, Lordship, they cannot deviate with the terms and condition of NIT.
So you wanted a retender.
Fresh tender, Lordship. So that
Fresh tender, you will now know what is the amount quoted by your competitor.
even Lordship, I'll get
Now offer better rates within 10%.
Lordship,
And
not
who will-
only me, Lordship,
and-
all the
And who will help you to do it? The board. That can be done. You now know that these rates are declared now. The work is same, the tender condition, tender price, what is that? Tender value will remain the same.
yes, Lordship.
So you will know what rate is necessary to bring it below, within 5%.
It will give opportunity to not only the petitioner, Lordship, in fact, all other 5 bidders whose bid has been rejected by the board members.
They are not before the board.
Yes, that is there, but if fresh tender will be issued. Lordship.
Yes. Anything more?
No, no.
Submit any judgments.
Yes, Lordship, that I'm going to rely. The state or its instrumentality has to act in accordance with the conditions laid down in the tender notice. So 1986, 3 SCC, 247. There are 19 notes.
86.
86, 3 SCC, 247. There are 19 notes. The state or its instrumentality has to act in accordance with the conditions laid down in the tender notice.
Yes.
Arvinder Singh. Yes, Lord. Arvinder Singh Arora versus Union of India. Right.
There are 19 or 9. There are 9. 19.
It is contended for the appellant that the tender submitted by the respondent 4 did not satisfy the requirements of para 2 of the tender notice. The tenders had been invited for the supply of your fresh buffalo's milk or fresh cow's milk, but the respondent had submitted tender for supply pasteurized milk. And therefore, the tender submitted by the respondent for being not in conformity with the tender notice should not have been accepted by the authority. In any case, if the tender of respondent for regarding supply of pasteurized milk was accepted and the original terms of the tender notice were changed, the appellant should have been given an opportunity to submit his tender in conformity with the changed terms, but this was not done, which has been which has caused serious prejudice to the applicant. If the tender form submitted by any party is not in conformity with the conditions of the tender notice, the same should not have been accepted, but the authorities concerned arbitrarily and in a fanciful manner accepted the tender of respondent form. The state or its instrumentality has to act in accordance with the conditions laid out in the tender notice. Limited versus State of Tripura and others, 2002 GLT 590. Here almost same, the judgment of Harminder Singh has been referred. FERA 7 and 8. Is provided that it is needless to point out that a NIT is a promise made to the intending bidders, and the authority making such promise.
What is the citation again?
2000 volume 2
Volume,
volume 2 GLT
yes,
590 laws
right.
and relevant FERA 7 and
What is the name of the party?
40 laws PSC Engineers Private Limited versus State of Tripura and others.
Paragraph?
There are 7 and 8 laws. There are 7 laws. The question would naturally arise whether the state authority can step beyond the requirements of performance certified from the specified authorities as provided in the NIT. It is needless to point out that a notice inviting tender is a promise made to the intending bidders, and the authority making such promise will not normally be permitted to deviate therefrom, except where the element of public interest necessitated such deviation. And then same Harminder Singh Arora case has been referred to, so just down to them. And next para 8 goes. So far, permissibility of departure from the NIT specification is concerned, it would be relevant to refer here to the decision is so and so, wherein it has been observed that an executive authority must be rigorously held to the standards by which it professes its action to be judged, and it has no alternative but to scrupulously observe those standards. To be more precise, there is no scope for any deviation from the eligibility conditions specified in NIT. Then next is lordship, if the certain rules and laws requires that a particular thing should be done in a particular manner, it must be done in that manner only. That judgment that is in 2014 3 SCC 503. volume 3 SCC 502 logs. Figure 61 and 7.
One and
61 and lordship 70.
sorry.
Yes. When settled that where this provide for a things to be done in a particular manner, then it has to be done in that manner and no other manner. These propositions of law laid down in Taylor versus Taylor was first adopted by the Judicial Committee in Nazir Ahmad versus King Emperor, and then followed by a bench of 3 judges of this court in Rao C. Bahadur Singh versus State of Vidya Pradesh. This proposition was further explained in Para 8 of the State of UP versus Singhara Singh by a bench of 3 judges in the following words. The rule adopted in Taylor versus Taylor is well organized and is founded on sound principle. Its result is that if a statute has conferred a power to do an act and has laid down the method in which that power has to be exercised, it necessarily forbids the doing of the act in any other manner than that which has been prescribed. The principle behind the rule is that if this were not so, the statutory provision might as well as not have been enacted. So here instructions, Lordship, in the NIT and CPWD manual regarding the acceptance and rejection that has to be followed. That is my contention.
This is, principle is primarily with regard to statutes.
Yes, this is regarding is the
Here is a case where, of course, you are saying that this principle should be implemented in
implemented in the cities. Because that is terms and conditions that NIT has to be followed.
how.
My Learned friend is harping on clause 14 at page 41. This is the first ground, and the second ground is that when the variation is between 5 to 10, there should be a reason assigned. But first, we'll come to clause 14 at page 41, my lord. I'll trouble my lord. Again. Still, he's only on to that. So as per clause 14 of the NIT, there should be L1, L2, L3, 3 firms should be mandatorily recommended. That is the first ground. And the second ground is that when the variation is between 5, above 5 and below 10, there should be a ground assigned for accepting that. My lord will kindly see page 41. Page 41, clause 14. What it says, the tender shall be evaluated by the boards constituted by the DC cum DPC at the district level and recommended at least 3 firms, L1, L2, L3, and L3 to competent authority for acceptance along with all relevant documents. Then the joint director RE shall further scrutiny the tender documents recommended by the project director. The LOI will be issued to L1 firm if the tender documents recommended by project director is up to the satisfaction of acceptance authority. My lord, I'll directly jump to the last page, means the impugn evaluation. Last page at page 308. What it says, L1, L2, L3 has to be. Now, if my lord says, what are the rates quoted? First is the private respondent, who is L1. But serial number 2, MS Benji Loma Enterprises, he quoted minus 20.02%. He will be the, if all the rates are directly calculated, he will be the L1. Well, clarify this. I'll take my note to our affidavit. Starting at page 324.
Eight.
324. 324.
24.
Yes, my lord. This is the tenders, our affidavit.
Yeah, but it.
It's part of the tender summary report. Yes, my lord. This is part of the tender summary reports. My lord will kindly come to page 325. What? These are the 6 bidders, my lord. Number 1 bidder MSMG Loma Enterprises. Got value is given, then rank is L1. Then Nyabom Jilen, this is the petitioner, he is L5. Then MS DG Enterprise is L4. MSDK Enterprises is L6, the private respondent, who has ultimately become the L1. Yes. So even if we assume that L1, L2, L3 has to be recommended by the board, which they could not have recommended, but even assuming they should have recommended 3, then also it is the petitioner does not come because he is L5. I will be the private respondent will be L6. It will be the other 3 firms. Petitioner in by this argument also, relying on clause 14 also, his case could not have been recommended in any case. Then the next argument advanced is that he was arguing that if the variation is above 5% and up to 10, there should be a special reason given, my lord. My lord, to that, my lord, first of all, when the petitioner is above 10, in which case his bid cannot be accepted at any cost, he cannot raise this grounds, my lord, after being unsuccessful, my lord. The minutes clearly state that these all other bidders, the rest 5 bidders, they have been rejected because their bids are beyond -10, which in any circumstances cannot be accepted. Now, as per our affidavit, although there is no other reasons, specific reasons, but as per our affidavit, we have stated that only 1 bidder was within the permissible limit of 10, -10. So, to avoid further floating of tender and which could cause extra cost, my lord, and also time consuming, recommended his bid was accepted.
Where is work to be executed in which part, which port, which area?
Liromoba, West Siang District. Liromoba CD block road. No, madam, not road. It is Manrega project, supply of cement, sand, gravels, and all. These are when for creating employment to the people, my lord. Then supply of sand, gravels and cement and other roads and all. My lord will kindly see that what we have stated, that reason is that to avoid further plotting of tender, and then which could have cost extra expenditure, and to avoid time consuming process. That's the reason. And my lord, this LOI was issued to the private respondent on 24th of June at page 327. Summary and all this was on 7th of June. Then ultimately on 27th of 24th of June, the LOI was issued at page 327. Then after the LOI, the performance guarantee and all was also made. Then the supply order was issued for procurement on 27th of June. 27th of June.
He has already resumed.
Yes, my lord. June itself, my lord. And this writ petition was filed only on 28th of July, after a month of issuing of the LOI. After almost 2 months from the rejection of his bid. So, my lord, the work is in progress, my lord. Substantial progress have been done. Supply materials have been given, my lord. We have made statement to that effect also. So,
Is there any restriction in the contract or any laws say that there has to be a particular number of selected bidders in order to award the contract?
no, my lord. It is not here. Only in clause 14, what he has shown, that the board will recommend L1, L2, at least 3 bidders. But when there are only 1 qualified, how can 3 bidders be recommended? And then if L1, L2, L3 is to be recommended also, then it will not be him. It will be the other 3 bidders who have voted below him. My lord, I will just rely on Tata Motors that making out a legal point will not suffice, my lord.
Yes.
That's all, my lord. I'll just
Judgment,
yes, my lord.
just give us the citation.
Right. Citation 2023. SCC, page 1. I'll rely on the last pages only, last paragraphs. Oh, right.
Paragraphs.
Paragraph 53 to 59, my lord. In my Supreme today, the paragraphs are different, but SCC, the paragraph is. That's all. Uh, sorry.
Ronak.
No, my lord. Tata Motors.
No. Paragraph 52.
52, my lord, yes, my lord. Ronak one, that, I'll, after that, my lord, 55 onwards, my lord. Ordinary, writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tenderer, unless something very gross or palpable is pointed out. The court ordinarily should not interfere in matters relating to tender or contract. To set at naught the entire tender process at the stage when the contract is well underway would not be in public interest. Initiating a fresh tender process at the stage may consume lot of time and also loss to the public exchequer to the tune of crores of rupees. The financial burden implication on the public exchequer that the state may have to meet with if the courts direct issue a fresh tender notice should be one of the guiding factors that the court should keep in mind. This is evident from so and so study. The law relating to award of contract by the state and the public sector corporation was reviewed in Air India Limited versus Cochin International Airport, and it was held that the award of a contract, whether by a private party or by a state, is essentially a commercial transaction. It can choose its own method to arrive at a decision, and it is free to grant any relaxation for bona fide reasons, if the tender condition permits such a relaxation. It was further held that the state is in its corporations, instrumentalists, and agencies have to have the public duty to be fair to all concerns. Even when some defects is found in the decision-making process, the court must exercise its discretionary powers under Article 226 with great caution and should exercise it only in furtherance of public interest and not merely on the making out of a legal point. The court should always keep the larger public interest in mind in order to decide whether its intervention is called for or not. Only when it comes to a conclusion that the overwhelming public interest requires interference, the court should interfere. Hello. These two paragraphs is enough.
Yes.
Regarding Lordship, the recommendation of even his submission is even in case of recommendation of 3L1, L2, L3, the petitioner would not be in the list. Lordship, here my case is I am not claiming that the NIT tender work should be awarded to me. My case is, Lordship, when the clause 14.1 is not followed, it has to be by the competent authority, the board members whose duty was only to evaluate the financial bid and to recommend L1, L2, L3, how they can reject the rest of the bidders, lordship. Therefore, my failure is, lordship, it should be cancelled and fresh NIT should be issued because they have violated the terms and conditions. That too by the not competent authority, that is the board members, lordship. The duty entrusted to them is only to evaluate the financial bid and recommended it to the accepting authority, lordship. But that is not that. That is not that, lordship. And regarding issuance of LOI and work progress, lordship aware that the illegalities, they cannot get legal right from the Debt Act. Once it is violated, it has to be strictly as per terms and conditions, lordship. And regarding execution and subsequent development, lordship, if lordship this financial bid evaluation goes, the respondent number has always right to claim back the whatever the expenditure they have incurred from the authority because it was totally illegal. They cannot get protection from out of the illegal activities. That is my supposition. Be obliged.
Item 13 also.
12 and 13.
The
Only
only
the package work
Packages are different.
Yes, that is,
But the parties are same.
parties are also different.
For
but-
private respondent is
Yes, private respondent different lordship. But in that minus lordship 9.47. And again, the financial bid evaluation board has recommended the only one bidders, rest were rejected. And package, that is item 12 is for the supply of Mandrega items for CD block Lirmova, and item 13 is for CD block Dara. Or same NIT. So if you know that,
Yes.
deeply obliged.
obliged, madam.
Item number 14.
Yes.
This case only should to be looked into is whether the action taken by the Public Service Commission is sustainable. Well, in the eastern Arunachal Pradesh, the Arunachal Pradesh Public Service Commission
Yes.
is responsible for recruitment of various categories of officers. Well, basically, it is regulated under the Arunachal Pradesh Combined Competitive Examination Rules 2019.
Yes.
And for each examination, they formulate manual only for that particular exams. Only that is the instructions, the do's and don'ts, and certain the things which they can adopt if any situations arises.
Lordship, our affidavit is ready in court for swearing, Lordship.
APS,
Yes,
APPS.
Yes, Secretary was out of station. He'll be arriving today.
When can you file it?
If Secretary arrives today, then tomorrow. Notary will do it.
Just we can pick it up day after tomorrow.
Day after. Yes. Okay. You'd like to file reply or anything, case the affidavit comes.
No, my lord, only the question is double jeopardy, proportionality, and all this. These are legal submissions only.
Here is the issue where she has been debarred from the examination
And to 2024.
and the subsequent also.
Now, my lord, what happened is in 2024 there was an examination. In that examinations, the mobile phone was found from me, and accordingly, I was debarred from appearing that exam. So I also accepted. I did not protest. I did not create any aggravating situations. Now, after that, in 2025, they have again another advertisement.
Here I have applied.
There
My-
also you are deferred.
Yes, my candidature has been deferred based on the same sets of invitations, Madam. Only in 2024, I had carried a mobile phone. Only on the same ground, they have deferred me. Yeah.
Mr. Patel. No. Yeah, fine. Council, standing council first. They can stand council for APPS. Some steps. In days time, yeah, but we can fight. Thursday.
Item number 15.
Is your lordship. The content matter and the service report is awaited in this matter, lordship.
As per office note dated
Wait.
'25 2025. Service reports on respondents 1 to 7 are still awaited. Matter accordingly be deferred, be listed again after 3 weeks. 3 weeks.
Okay.
Item number 19 to 22.
Who is the person you want included?
Well, is an assistant engineer, my lord.
Assistant.
Engineer, my lord. My lord, in nutshell, my lord, the petitioner, my lord, has filed one writ petition, my lord. That is two, my lord. 284, my lord. Wherein, my lord, petitioner sought, my lord, he was given officiating promotion in the year 2007, my lord. And, my lord, it was regularized, my lord, and promotion was given only year 2019, my lord. Prior to that, my lord, we will file a writ petition, my lord, whereby, my lord, this honorable court said, my lord, that to identify the vacancy position of the promotional quota and to do necessary, my lord, give necessary, my lord, while, my lord, necessary placement of the assistant engineer and to hold the DPC, my lord. But, my lord, without considering the subcommittee report, committee's report, my lord, the DPC held in 2019, my lord, whereby, my lord, I was given promotion from the date of DPC, my lord. Then I will represent it before the authority, my lord. Then authority, my lord, issued an addendum, my lord, saying that, my lord, they will form a committee, my lord, again, to, my lord, reconsider our grievances, my lord. Thereafter, my lord, seniority list was published in the year 2022, my lord, without considering the, my lord, subcommittee report, my lord. And we have challenged the, my lord, the seniority list as well as the, my lord, for retrospective promotion from the date of officiating promotion, my lord. In that writ petition, my lord, lordship will find at page, my lord, 28, my lord. A direction has been given, my lord. Part is at, my lord, page 29, my lord. My lord, it is further provided that pendency of writ petition shall not be a bar for concerned authority to revisit the seniority position, my lord.
No, first, is that any objection with the IA? Let us allow this implement.
Yes, yes, my lord.
Mr. Arso, Thompson. IA number 208.
208, my lord.
This IA files treatment of which person responded? What the respondent?
Respondent number 9, ma'am.
Like with the applicants. Treatment. And the respondent, the number. Yep.
Weekly border, my lord, part, those you would find at my lord page 22, my lord. My lord, find at page 25, my lord.
26 is the effective part.
Yes, my lord.
Whereby an interim order was passed. The PPC number is number 24 of 2025 by the order dated 27/6/2025. That no final decision be taken in respect of them by the
No, my lord. My lord, the seniority list has been not been, my lord, refixed, my lord.
seniority provision has not been fixed as per your filed representations.
Yes, my lord. My lord. My lord.
Necessary part is affected by the issues raised in the petition and the past. Any government did? Yes. You are there. All right. All right. You give him a chair. In fact, you should give him an armchair. Mr. N. Ram. Whether it should have been state also the job of some rare meat like you know, without by limited post like within I or
My lord, I have some urgency here. My lord, last time, last week, my lord, the
file
matter,
it by next week.
my lord, the matter was listed before last year before Justice Ete, my lord, and he recused himself, my lord, from taking up this matters, my lord.
Oh,
My lord,
so we'll fix a date.
my lord, because my lord, kindly see for a moment, my lord, the DPC,
No, but you have to give him an
if,
minimum time to object if he has objection.
but because of
File
my
it
lord,
by Tuesday. Right, the personal, certain, but see that, application, you make it in. I file for, about second, third.
my lord, what happened in this case, my lord? They filed a writ petition, my lord, and obtained the interim order, my lord, by suppressing my writ petition, my lord. Though my lord, writ petition was, my lord, directed to be listed along with his writ petition, my lord. My lord, in my writ petition, there is a specific order. Lordship will kindly see for a moment, my lord.
Very good, right time, but I haven't seen. I have, but. Was, but. Petition 459.
My lord.
Page 72.
No ban to revisit the, my lord, seniority position, my lord. My lord, this aspect has not been brought before this honorable court while seeking that interim order, my lord. It's a contradictory orders, my lord. And my lord, the order has been obtained by relying upon a judgment which is not factually, my lord, applicable in this case, my lord. My lord, saying that, my lord,
We'll examine that, but you have to give an opportunity.
in that,
Right.
my lord, because then, my lord, in that case, my lord, the DPC was supposed to be held on, my lord, 8th of this month, my lord. Also, I have annexed the, my lord, schedule of the DPC, my lord.
We are fixing it on third. Third.
Before third, my lord, the next DPC will be held on 3rd, my lord. I was instruction, there's an instruction, my lord.
Just said eight.
No, my lord, it was supposed to be held on 8th August, my lord. Lord, you kindly see page 81, my lord. For a moment, my lord.
We'll direct them to defer it. To the implement. We'll direct them to defer it.
Yes, my lord. Yes.
Why not let it go?
Yes.
But why not? Order by not was passed, why not? The same issue was taken for a month. And I was so why not by reply, but in fact, the departmental authorities objected to the subcommittee. It's more political consideration, this has been done. And so you know, by not. There's no question of parking, by not. Notice in the eye also.
My lord, may kindly, my lord, defer the, my lord, DPC.
When is it held?
It will be held on my 3rd, my lord. I have the instruction, my lord. It was supposed to be held on only 8 August 2025. The composition of the DPC is, my lord, the Chief Secretary and others, my lord. Because of the visit of the Chief Justice of India, my lord, this, my lord, DPC was deferred, my lord. And it is slated to be, my lord, held on 3rd of the September, my lord. Now, my lord, they are the, my lord, the direct equities of the, my lord, 2009, 2012 and 2000.
Yes, government, when is the DPC likely to be held? You have clear instruction that you get it by. Are you confirmed by 2 o'clock? Yes.
Prayers, my lord. My lord,
How can you approve, can only who are affected by the interim order pass?
yes, my lord. That's why, my lord,
So.
if not vacated, my lord, the DPC may be, my lord,
But
departed.
hard time and comes to both parties. I bites. They're getting modification. They're getting modification.
27/6/2023.
27/16 bypass the number 84 of 2025. By the same. When that the filed by, you have filed representation.
No, my lord. My lord, pendency of the, my lord, writ shall not be barred to read.
You are seeking vacation of this 27/6.
Yes, my lord.
So 27/6, the committee was examining what?
Examining the seniority position, my lord, to refix the seniority position, my lord.
Is it on the basis of some court order representation? Representation made by the private authority, and it was not, he has not been private respondents in the writ petition. The committee or the committee was examining the representation in the made by the private respondent. Leader of
Assistant
Assistant Engineer in the Department of
Hydropower.
Hydropower. So this this writ petition, right? Final decision taken by the doubt. And the writ petition was directed to state along with three other writ petitions being WPC 95, 24, 14 of 22, and 459 of 32. So where is this interim order that present high that the applicant spot on number 6 vacation of my time, Mr. Time. Applicant is vacant. By permitted that better. Considering sufficient right. Third.
State of the DPC.
You request someone to appear. In case there is any difficulty, we'll accommodate you. But considering the pressing issues raised by the council, the parties, they're agreeable on third. So if there is anything to be done, we request you to come back on fourth or fifth. In case, because this is the question of the vacating petition. So. But it's by 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 the next week. Advance for so but I the matter the third
Item number 23 and 24.
May I please, my lord? But this is an application to apply the applicant himself as a matter petitioner in the main writ petition matter.
Include the,
Applicant
uh,
as a matter writ petitioner number 3 matter in the writ petition matter.
yes, any,
I am allowed. Lords may allow the.
why do you want to join hands to?
My lord, the lane, the present my lord, one airstrip my lord at Anini my lord. The lane was my lord allowed to my lord operate airstrips my lord for the army my lord in the 1962 my lord war my lord. And now my lord, the army has abandoned the my lord airfield my lord. So we are reclaiming back the land. Or if they want my lord, the authorities want, they have to my lord, the initiate land acquisition proceeding my lord.
Vehemently objection, my lord. My lord, it was never abandoned, my lord. That area is, my lord, advanced landing ground. Still, we are using that, my lord.
No, in affidavit
no.
of deputy
No, no.
commissioner,
No, but,
I'm sorry.
how are you connected to the?
But-
my lord, our forefathers, my lord, the petitioner number 1 and 2 is there, my lord. My
Who are they?
the father of the my lord petitioners, and when I have made a statement in the writ petition also, my lord. Third, my lord, person who donated land is the applicant's father, my lord. So I want to
File a separate writ petition.
my lord, is my lord,
I'm
that
afraid,
is
my
one
lord,
of the, my lord,
they are trying to build up the, my lord, case, my lord.
File a separate.
my lord, common cause, my lord, this one.
But the claims are separate, no?
Let's
Same.
say,
My same, my lord.
It is
How
not
there can
one
be two
parcel
owners?
of land. The petitioner, existing petitioner, has a claim over the land donated. Likewise, your father had donated some other land, which is contiguous.
Well, in the same strip, my lord.
Maybe.
My lord.
But it is not one
piece of,
portion of land, like say, 3, 4 brothers are there. Their land collectively is donated. It's not a case like that. You have a separate land.
No, my lord, same land, my lord. My lord,
How can it be the same land? There are different claimants. The petitioner's fathers have donated one portion of land.
Right.
In the same area.
Right.
Your father has donated another plot of land, adjacent land maybe.
no, same, my lord. Together, my lord, we three, my lord, fathers, my lord, has donated their lands. my lord.
On what basis are you?
So, kindly see my writ petition, my lord. Paragraph 3, my lord. The petitioner begged to state that on repeated requests made by the district administration of Ani Dibang Valley, the petitioner's fathers, namely late Sake Tayu, late Kasame Miho, and one late Yuko Melo, my lord. Yuko Melo is, my lord, the present applicant's father, my lord. But at that time, my lord, of filing writ petition, I cannot join, my lord, because, my lord, I was out of station, my lord, for some personal difficulties, my lord. So we could not join, my lord, in the main writ petition, my lord. That's why, my lord. Four, four, one. For turning back the land, or matter if they record the land, matter,
Or a direction, respondent authority. Acquire the land.
acquire the
Acquire
yes, madam.
by formally.
Due process of
So it is submitted by the applicant that fathers of petitioner number 1 and the father by the saying that, but
Yes.